Mr. Murray, what we have discussed in our email here, I sent you an email back for clarification that you never really replied to. You
Yes,
basically told
I
me that you wanted to call rather than talk to me via email about it.
yes, I prefer to speak to you as opposed to just emailing back and forth.
Okay. So in here, I asked you to clarify on here that what the report said that was on the that you guys had there with nature of the charges. I'd asked you if the officer had put down the information. I was also asking you to clarify if the Peterborough Police or Peterborough Regional Health Center had done their job within this case, in your opinion.
Well, I can't offer you an opinion on that, sir. I can indicate what they provided to us. I can't discuss because there's a confidentiality with respect to police reports. You can make a request through Peterborough Police, through Freedom of Information Act and Personal Privacy Act, if you wish, to get copies of whatever materials that they are in their possession. But what was provided to the Crown was a documentation supporting a charge for an assault,
Okay,
and that's what the Crown proceeded on.
so there was no indication on there stating that I had an injury to my head.
Sir, I'm not going to discuss what was in those particular materials with you. The charge was assault that was laid by the police, and I'm not in a position to disclose to you um, Peterborough Police documentation.
Okay, so I need to go through the police for that part. That's fine.
That's correct.
Now on the, so I'm guessing the Peterborough Regional Health Center part is a part of that as well, correct?
Uh, I'm presuming so. I can tell you there was no documentation in the file from Peterborough Regional Hospital
Okay,
or
that's
the health
good.
center.
That's good to know, considering that now I need to go up there and talk to the admin there regarding the fact that they didn't file the reports correctly. Okay,
Well,
so
there's part of that would be they can't provide the reports directly to the police. The police, the way it works, because it's your personal
the
privacy.
police
It's the
requested
same.
it, which I gave them authorization to have all the records transferred from to them at
Did
the
you
hospital.
did you sign a consent form for that,
Yes, I
sir?
did.
Okay, so
They
I
had all the information, so now that's a failure on the police. Okay. All right. Now, the other part I have here is you said it was an oversight that your office did not contact me regarding the plea or discuss it with me. And you said that you never saw any attempts that were made.
yeah.
Um, Now, I'm going to state this as a call center rep when I was at my work there. If I had made a mistake like that, I would be fired on the spot.
Okay. Well, we don't fire people for that, sir.
Okay.
It can indicate pursuant to the Victim Bill of Rights. It's my view that we should. I don't run the Peterborough office, but it's my view that we should, as Crown officers, attempt to contact victims for input in relation to you're entitled pursuant to the Victim Bill of Rights to provide input when somebody is either found guilty or pleads guilty
So I
to the
was
court. Excuse me, to the court in that regards. I didn't see any attempts in the file. Now there may have been, and it wasn't recorded, but I didn't see any attempts in the file to contact you to ask you for input that would be provided to the court for purposes of sentencing. I brought that to the attention of the Crown manager in Peterborough and told him that that's not within the policy and that should have been done, as it should be done in every case where there is a victim of crime, as because of the Victim Bill of Rights.
so in your opinion, my victim bill of rights has been violated,
Well, sir, I'm not going to say that. That's not my opinion.
but that's
As
what
I
the
said,
facts are directing at.
well, sir, you can make your own conclusions, but from my perception or perspective in reviewing the file, I did not see any attempts to contact you, and that, in my view, was an oversight, and that should have not been, that should have not occurred in that particular fashion. I don't believe it would have changed anything at the end of the day, but again, it is our duty, in my respectful opinion, that we contact victims to advise them when pleas are happening in case they wish to address the court with respect to the impact that has occurred as a result of the crime.
So I'm going to ask another clarification on that question there. Under the Victim's Bill of Rights, does it actually state that you guys are supposed to contact the victim in the suggestion of a plea or in guilty considerations?
I think you need to look up the Victim Bill of Rights. It says a lot of things. It doesn't say that in that specific language, but it does indicate we are to make attempts to contact the victim and for purposes of providing input. And usually, and again, I wasn't present at the time of the plea and the sentencing, usually the court will inquire of that as to whether the victim has been contacted or attempts have been made. Again, there was no notes in the file. That doesn't mean someone did not try to contact you. So I can't say for sure that didn't happen. We're not required to absolutely contact you. We're required to make effectively best efforts. And I was unable to determine whether anyone had attempted to contact you or not because there were no notes in the file indicating that they had.
Okay, and I can conclusively tell you they did not contact me via email, phone, or anything because I've checked my voicemails, I can check records, and I can cross-reference numbers. I can get all that from Credo. There was no attempts made to contact me. Victim Services contacted me, and the worst part about that is after you guys did the guilty stuff, I had to contact Victim Services to get the information as him being charged and
yeah. Well, then that's something that the Crown's office would have had the information from Victim Services. So in one sense, we did comply with our duty then to contact you. It doesn't have to be the Crown specifically.
I had to contact them, sir. They didn't contact me in January.
But you indicated to me, you just indicated to me that Victim Services contacted you initially.
They contacted me initially a couple days after to do the procedure for what was going on with his sentence, what was going on September 5th when he was charged, his court date,
right.
How he missed his court date 3 times before he was brought in, and how he, failed to appear for court, which still, in my opinion, that's obstruction of justice. The other part on that is that I had to call them I think it was February. I called them. It was when I got the information as to the trial had been completed without me being known for over a month at that point.
Okay. Well, first of all, sir, it wasn't a trial. It was a plea. Okay, and everyone's entitled to plead guilty should they wish to do so. And what you've told me, and again, what we do in our office as well, as I know in Peterborough and other places, is that if contact is made with a complainant, so a victim such as yourself, with our victim services or victim witness assistance program, that is input that we have in order for us to move forward. So you've corrected me on that there was some contact made with you by the office. So
sorry for the dog in the background, by the way.
No,
my
landlord
just got home.
Sounds cute.
He's an Australian Shepherd. All right. So on that, I still feel it isn't right that I had to, call in and ask what the status of the trial was, or not trial, or the process myself. Sorry, so that so I could get the information. Now, are you able to disclose to me how many charges were dropped in the case?
No, sir, because there's a lot of matters that didn't involve you. As I recollect, he had a number of charges that were outstanding, including, as you mentioned, the failed to appears. I think there were some other
2 assault charges for me and Tatiana.
Yeah, but no, it would be appropriate for me to discuss what he ended up pleading to or not pleading to, again, because that would violate his privacy rights.
So I have to do a FISA request on that. Okay.
You could certainly request. I believe the court docket would be public for that particular day, but or you could order the transcript if you wish.
I don't have the money to do that, sir.
Yeah.
So at this point, right now, what's inhibiting us from being able to see this stuff is now the factor of money, which I think in the case of a victim, they should be able to get that stuff free of charge.
Well, there are privacy rights that go beyond, and again, similar with yours, sir. We wouldn't disclose your statement or your medical records to anyone that just asked us for it. We are confined and constrained by the Freedom of Information and Personal Privacy Act as to what we are able to disclose on any circumstances. I can disclose in relation to you that he did plead guilty. that he accepted responsibility for the assault on you. The Crown did seek a
30-day
more
sentence.
substantial, more substantial penalty of 30 days, and the judge imposed a period of 5 days, if I recall correctly.
5 days that were pretrial detention served already.
That's correct, and usually what that means is normally it's calculated as 1.5 to 1, so it's effectively the equivalent of 7.5 days or 8 days.
That's, still in my opinion, he should have been sentenced to 18 months in prison for his charges that he had.
I can appreciate that, sir, but that's we're guided by the principles of sentencing that we have in circumstances of the offense and the offender, in circumstances of specific and general deterrence, in circumstances of denunciation, and in this particular case, as you've already noted, significant mental health concerns in relation to this individual.
And which I, as far as I know, there has been nothing done. I haven't seen him around town. Now, now let's move on to the person at the office at Peterborough, which is one of my really big things I have with you guys right now.
Yes, sir.
And so the guy at the office said to me, and I quote from this because I can still remember this: the attorney chose the path that would get the conviction and save the taxpayers money. That is one statement that was said to me by this person that was there during our conversation.
Yeah, I don't know the context of what led him to say that particular statement. You're certainly in your emails you've indicated that you wanted the matter to go to trial. We do not set matters specifically for trial if someone is prepared to plead guilty and accept responsibility. And again, we asked for what the Crown sentencing felt was the appropriate penalty in relation of the circumstances of the offense and the offender, and the judge actually imposed less than what we were seeking in that respect. So we can't tell people that they can't plead guilty, sir. We can't
I,
say we're just
I
going to
do
run a
understand
trial.
that, but
Yeah.
that statement that was made is, in my opinion, the incorrect one. It goes against the mandate of the Crown Attorney.
In what sense, sir?
That's stating that you guys are going for the easiest path to conviction to save the money rather than ensuring justice for the victims.
Well, we may be at not at Edom in respect to what you feel is justice for the victims, Mr. Gillis, because certainly the Crown took a plea based on the information they had to the assault on you. As I understand it, the facts were read in as to what occurred on that particular day. Mr. I'm sorry, the gentleman,
Mr. Willis.
Willis. Sorry, I didn't want to confuse the two of you, because similar last names. Mr. Willis accepted those facts. Submissions were made, again, seeking a lengthier custodial penalty and a period of probation to follow, and ancillary orders such as no weapons and DNA. And the court chose not to impose what the Crown was seeking, but imposed a lesser penalty in that respect. That is, a part of our justice system. When people plead guilty and we seek what the appropriate penalty is, in law, it may not be the appropriate penalty that you feel is right, but we have to. We're mandated by precedent. We're mandated by the facts of each particular case, and in my view, that's what the Crown did. The one oversight, again, and maybe it wasn't entirely an oversight, is the lack of what appeared to be lack of contact by the Crown's office to you. But certainly, as you've told me, victim witness did contact you at the early stages, and whatever you indicated to them would have been provided to the Crown as part of that package.
Yep, and they knew I had a head injury because I indicated that as well with them. We also indicated that going to what's the other one? The victims' compensation. I can't remember what they're called. I've got an email.
Victims of crime. The
Yeah.
compensation board. Yeah.
Yes, yeah, they got
Yeah.
the report as well of the concussion and all that. Now the part that really that here is you say you can't identify the person who I had the meeting with at the office. Uh,
I asked the head Crown there, the Crown attorney, if he was able to to let me know, so I can speak to that individual who dealt with you on that particular day, outside of a male individual, and there's at least two, well, three males in that particular office, as I recall correctly. That arose from your email. He wasn't able to tell me who it was specifically. So,
Okay, so on that, there are,
but again, I alerted him again of the concerns that you expressed, and I'm hopeful he dealt with it within his office.
here's the problem with that I see is there's a lot of CCTV cameras in that building. I have been in this building many times for stuff for photography because I was part of Spark this year, and one of the big exhibits was there. So I know there's a lot of cameras in that building. I know there's at least 3 or 4 cameras in the main office area of the building. For the office for the attorney general there, so there is a way you guys can identify him, and I'm not sure why you guys did not go to that means to try and identify him.
Yeah, I don't know. Well, two reasons, sir. I'm not aware of any cameras in that attorney general in that particular Crown's office within the maybe out in the hallways, maybe down in the front foyer, but within the Crown's office, you say there's cameras.
There should be one right
Well,
in the front area, but
I don't believe there is, but I may be mistaken about that. Um, we don't get access. Again, sir, this is a privacy issue. We don't get access to cameras automatically just because we ask for them. If that particular building, I forget the name of the building, I know the Crown's office rents space out of there, but if that particular building has its own security system, they will only turn those matters over to the police if there's been a crime committed or other circumstances, because we live in a very video and photographic
sir, I'm a
society.
photographer.
And
You don't need to inform me of that.
well, that's you understand then, sir, that we're very a part of our laws is I don't just get to go look at cameras, at video film. We have cameras here in this particular courthouse that I'm at presently in Durham, but they don't record. They're only security cameras, and there's a security office down there. But I can tell you there are none in the Crown's office, per se. And if there was, and I can tell you, normal circumstances are to get video. Usually, you have to obtain a search warrant.
So on that as well, I'm gonna sort of correct you a little bit on the camera part. So within that security room down there, they do have a server that does record the stuff and records it for up to 30 days for legal purposes in case something happens. So
In that particular building. I don't know about.
No,
I may be
that's
correcting you on the.
that's normally
Yeah,
standard for everywhere within security if you are doing that. The only reason I know that is I have friends who work in security, and they've gotten subpoenas in the past for information regarding videos, and that they have to keep record for 30 days of the file.
yeah, you may be correct on that, sir. I'm not going to debate it with you as it relates to the Durham Region Courthouse, which I work in.
Okay. Now, the part here that we have as well within regards there, so the oversight, in my opinion, like I said, that is a major sticking point that, in my opinion, is a failure. And I hate to keep going back to it, but it is, it's not a great
And
thing.
and
To,
I concede that, sir. That as I said, my review of the file suggested that there had been no attempts to
okay.
contact you. That no notes were there. You've corrected me on that by indicating that the victim witness program did contact you,
The victim
and there are
services
notes.
program from the Peterborough Police Department contacted me. It was Christy, one of the detectives there.
Yes, I
She
know. I
con.
know. Actually, I know Christy
Okay.
from when I was up in Peterborough.
So you
But
probably know my aunt Deb then too.
possibly.
Debbie Gillis, one of the sergeants
Yes.
on the Peterborough Police Department, helped bust a big thing in 2006 with the Hells Angels and the Outlaws.
Yeah, I know. I know Detective Sergeant Gillis very well. Actually, she used to work at Durham Regional Police.
Yep, she did. She used
So
to, and I have a picture of me in that car from when I was a kid. So I
there you
know,
go. Yeah.
I'm not that too far off on the law. I do look
No,
at it. So,
I know. And sir, as I said, so you're talking victim services of Peterborough Police, and I appreciate that. And I don't know the particular scenario, I haven't been in the Peterborough Crown's office since 2012, so I don't know what systems they have in place for when victim services provides information to the Crown and puts into the Crown package. In that, I didn't see any, and again, my view is that, and I instruct the folk in our office here that they should be at least advising a victim if they wish to make any submissions as a result of the impact of the crime to the court when the matter is resolved either by plea or finding of guilt after a trial. That's, I think, our mandate. And as I said, I apologize to you for that particular oversight. I don't know if it would have made a difference. It may have, but
Hindsight's 2020.
I don't know that. And again, the circumstances of the plea were such that the Crown did seek a more punitive sentence that the court did not agree with at the time.
Okay. So I think I've gotten all the information from you because the last one here is just about the protection order, and I can tell you it's pretty well next to useless considering I live less than a kilometer away from Mr. Willis, where his last known address.
I thought you indicated to me just earlier you haven't seen him in town.
I haven't seen him in town since March, after my birthday. So the last part I have up on here, I don't know if you read the email that I sent to you, but he came up to me on my birthday and asked me for smokes and change. I
read every email. I don't recall that specifically. But if he was on a probation order at that particular time, sir, which the terms are for him to remain away from you and not have any contact with you, which I believe that was the terms of the probation order.
It was to stay 100 meters away.
Then you should be contacting the police immediately.
I have contacted the cops in the past, and he's either gone before they get there and they can't find him, or when he's just caught and released.
And I can't comment on what the Peterborough Police does with respect to the breach of probation, sir. But the normal circumstances, when we have breaches of contact orders, probation orders, usually if the person's not on site right then, the police, at least here in Durham, issue a warrant in the first for their arrest in that regards, and they will pick them up when they find them and charge them with the breach of probation. Should they have reasonable probable grounds to believe that the breach occurred. So I can't, that's an investigatorial circumstance that if there is, and for your own safety, that protection order is there for that purpose. And if he is to wave at you, speak to you, anything such as that, you should be phoning the police immediately. And providing a statement, and he should be, in my view, arrested for breaching that court order, which has told him not to have contact with you.
Unfortunately, that hasn't occurred sometimes there. But the other part as well, the reason I say the protective order doesn't really work is I'm currently unemployed, been on welfare. I have to use the food banks. The food bank is right beside where he lives. That I have to go to. That's the other reason that this doesn't really work.
He's the one that's covered by that particular order, sir. And I don't know.
I know
in front of me as to whether there's a distance provision or otherwise. A lot of these orders have he's not allowed to be within
100
X
meters.
Number of meters within your place of residence, place of employment, place of education, place of worship, or any place you're known to be. There can be occasions, and I've seen it happen, where people end up in the same restaurant or bar or store, and he is bound by the order, so he is required to leave. You can't, you can't use it as a sword.
Well, I'm not trying to.
Require, but similarly, if you were going to the food bank and that's just around the corner from where he lives, maybe he's technically in breach of that particular 100-meter provision, which might just be as a result of you having to obtain those services. But he should still not be speaking with you.
Yeah,
that to me is, if he does approach you and speak to you, then again that is a criminal offense, breach of probation. That should be reported to the police, and they can investigate. And if they have reasonable probable grounds, they can arrest him.
Okay. I think they picked him up for something, so I haven't seen him around town in a bit. Either that or he's moved or, gotten into the tent city. I can't really comment where he is right now, per se, you know.
Yeah, I don't know if anything else has before the court at this juncture.
Yeah.
Oh.
Is there any way that, like, because that probation order on there, I I'm just trying to think here because I know I want to know because I would want to know where he is so I can avoid where his home area is per se. Would I have to do a visa request from the cops to find that out?
We don't deal with visa. It's Freedom of Information Act.
Well,
Visa is an American term,
yeah, I'm just using the American
I
term for
understand.
it.
I understand what you're saying. Um, I would. I would. I can't recall if it's a reporting probation or not. I would probably contact the Peterborough Probation Office,
Okay, do you
and they would be
know?
able to. They'd be able to tell you if it's a reporting probation, and that you're interested in not dealing with that. Peterborough Police may or may not provide you that information,
Okay,
simply because, again, to do so, they would. Uh, we tend not to, we don't disclose where you live. It's certainly the Crown or the police wouldn't disclose where you live specifically
sure, but I'm not
to
the
any
one who was
person.
attacked. I'm not the one who
I,
attacked the person in the end there. So,
I understand that, but I mean usually we don't report back to people where somebody is living, even as a victim. I mean, in that circumstance, unless there is a specific concern.
okay. Well, I think we're all done on our call here. So thank you for
Okay,
allowing me to call you, and
no
I
problem.
will email you if I have any more concerns.
Okay, thank you, Mr. Gillis.
Thank you. Have a good day.
Take care. Bye bye.